Welcome back to Politics USA. Today we're breaking down one of the most dramatic and unusual political moments of the year. In the past few days, you may have seen headlines claiming that Congress has slammed President Trump with 7 impeachment articles, while federal judges prepare potential jail consequences for members of his administration. It sounds like a political earthquake, and in many ways it is. But the real story is more complicated and more revealing than any breaking banner suggests. What's happening right now is a rare collision. 2 branches of government applying 2 very different kinds of pressure on the same president at the same time. And the way these forces converge tells us something important about how American institutions react when they believe a president is pushing past constitutional limits. To understand this moment, we have to start with the impeachment effort. Representative Shri Thanadar from Michigan has introduced a formal impeachment resolution against President Donald Trump. This isn't a symbolic speech or a fiery press conference. It's House Resolution 353, an official document filed into the congressional record containing 7 separate articles. These articles accuse the president of obstruction of justice, violating the duty to faithfully execute the laws, seizing congressional spending power, abusing trade and war powers, violating First Amendment rights, establishing unlawful offices, engaging in bribery and corruption, and finally, a charge using a word almost never used in constitutional filings: tyranny. That word alone signals that Thanadar isn't accusing Trump of a single lapse or scandal. He is accusing him of reshaping the presidency into something fundamentally outside constitutional boundaries. Now, an impeachment resolution does not mean the president has been impeached. It is the beginning of a process, not the end. Thanadar used a procedural tool called a privileged resolution, which forces the House to act. Lawmakers cannot bury it indefinitely. They must vote to adopt it, reject it, table it, or refer it to a committee. That doesn't mean Congress is on the verge of removing the president. The House would first need a majority to adopt the articles, and the Senate would then need a 2/3 vote to convict. We are nowhere near those numbers. But this resolution forces Democratic leadership to confront a difficult question. Will they publicly attach themselves to the word tyranny, or will they push the resolution aside and risk backlash from their own voters who want a stronger stance? Even if the resolution never advances, the act of filing it shifts the political conversation. It expands what lawmakers consider acceptable rhetoric about presidential power, and it signals that some members believe the presidency has crossed constitutional lines that cannot be ignored. At the same time that Congress is wrestling with these articles, a very different process is unfolding in federal court. Judge James Boasberg in Washington has issued a ruling finding probable cause to hold Trump administration officials in contempt for ignoring his orders in an immigration case involving Venezuelan migrants. The judge instructed the administration to halt certain deportations and even to turn planes around mid-flight. Instead, the administration allowed the flights to continue. In his ruling, Boasberg described what he saw as willful disregard of a court order and laid out a path toward potential civil or even criminal contempt. Civil contempt could involve accumulating fines designed to coerce compliance. Criminal contempt, although rare, can involve fixed jail sentences. Judges do not invoke contempt lightly. It is a serious tool meant to enforce the authority of the courts when the government refuses to obey lawful instructions. If you're watching from home, you might wonder how real these threats are. Does this mean Trump himself could be taken to jail? The answer is almost certainly no. Contempt usually applies to officials carrying out orders, not to the president. But the fact that a federal judge is openly discussing contempt at all shows how strained the relationship between the executive branch and the judiciary has become. For judges, this isn't about politics. It's about compliance. When court orders are ignored, the entire legal system begins to wobble. Historically, executive branch officials follow judicial rulings even when they strongly disagree with them, because non-compliance brings legal, political, and institutional backlash. When a judge sees a pattern of defiance, not a one-time mistake, they escalate. This is where the impeachment story and the contempt story intersect. Congress is accusing the president of bypassing constitutional constraints. The courts are accusing his administration of disregarding judicial authority. Both branches are describing the same pattern in different languages, a presidency that treats limits as optional. That's why this moment feels more consequential than earlier impeachment discussions. The pressure is not coming from one branch, it is coming from two simultaneously, each using the strongest tools they have. But it's important to separate what is technically possible from what is realistically likely. Could the impeachment articles eventually lead to removal? In theory, yes. Could contempt lead to jail time for officials? It's possible. But these outcomes remain far away. What matters more right now is the institutional signals being sent. The act of filing impeachment articles, especially ones that accuse the president of tyranny, sends a message inside Congress, inside federal agencies, and inside the White House. It forces lawmakers to clarify their positions. It forces career officials to wonder how far they are expected to go. It forces judges to decide whether they believe the administration will ever take their rulings seriously. These signals shape behavior long before any final vote or sentence ever happens. Inside the executive branch, the pressure from Congress and the courts forces difficult decisions. Staffers begin asking whether they may personally face contempt charges. Legal advisors warn about exposure. Some officials distance themselves from controversial orders. Others double down, fearing that stepping back signals weakness. Administrations rarely collapse because of a single scandal. They unravel when the people around the president begin making choices based on self-preservation rather than loyalty. Political parties feel this pressure too. Republicans worry about appearing indifferent to accusations of constitutional violations. Democrats worry about being accused of overreach. Leadership in both parties must calculate how their decisions will resonate with independents, donors, and the media. For Democrats, endorsing sweeping impeachment articles risks alienating moderates. For Republicans, defending a president accused of ignoring both Congress and the courts risks losing institutionalists within their own coalition. This is where the crisis becomes broader than Trump himself. When the executive branch treats congressional limits and judicial rulings as negotiable, the effects spill into the everyday world. Policies shift unpredictably. Court protections become uncertain. Communities that rely on judicial orders for safety, status, or legal clarity suddenly find those orders overridden. The rule of law becomes less of a guarantee and more of a suggestion. The deeper story here is about what the Constitution expects institutions to do when a president challenges its boundaries. Impeachment exists to check executive power. Contempt exists to enforce judicial authority. But both tools were designed for a political culture that assumed presidents would generally accept constraints. When a president repeatedly rejects those constraints, the tools themselves begin to show their limits. Congress doesn't want to impeach constantly. Courts don't want to jail officials. These are extraordinary measures, and the fact that they are being discussed in the same week is evidence of how strained the system has become. We're watching a clash between two visions of the presidency. One vision sees the office as limited by Congress, courts, and long-standing norms. The other sees those limits as obstacles to be pushed aside when they interfere with the president's goals. The impeachment articles argue that Trump has embraced the second vision. The contempt ruling suggests the same. And together, these actions reveal a constitutional stress test that will define the next chapter of American politics. As always, we will follow every development closely and break it down here. Thanks for watching Politics USA. Stay informed, stay aware, and take care.